often have you seen this sort of tactic being used, Nicholas, really with Apple sort of getting ahead of an ultimate potential ban and trying to force consumers perhaps hand here?
It's actually been very rare in recent years, primarily because injunctions or exclusionary relief, like a ban on importation, have been pretty rare in patent litigation since Supreme Court decision in about 2006. So there just haven't been occasions where a major player like Apple would frequently face this kind of situation.
Of course, we were just debating as to whether the US trade representative or indeed the administration would in any way step in here, overrule. Just give us your perspective on what the pros of doing that and what the cons are of ultimately a government weighed in here.
Well, I mean, the pros are obviously people like Apple Watches, and it would be a politically popular decision. The cons are that it doesn't, it doesn't promote innovation in the U.S. because that's why patent rights are important. And a company like Masimo is entitled to either license its patents to Apple on the terms that they think are appropriate, or to use their exclusivity from the technology they developed to gain market share. And if Apple if Apple doesn't want to do a deal with them or come up with its own solution to the technical problems Masimo solved, then then Apple's going to face a ban like this, or at least have to offer products that don't have this feature.
We were speaking with the CEO of Masimo this time yesterday, and his points were clear. He felt that his chief technology officer, his chief medical officer had been lured over to Apple. There was nothing he could have done in terms of paying it even further. They just had the resources that couldn't be matched by a smaller company such as Masimo. And I'm interested as to the other clients that you serve, the conversations you have. How much is this sort of behavior happening, if indeed it is exactly what occurred?
So I hear that kind of story all the time from clients of a large technology company taking their intellectual property, be it trade secrets or patents, and then using their other market advantages to beat the smaller guy. Patents are fundamentally a tool of small companies, and we need them to incentivize small companies to invent the next technology, because small companies are where the groundbreaking innovation tends to occur. And if the bigger guys, they're always going to win if they're allowed to copy, because they have the pre-existing market advantages. They've got a well-known brand, a consumer base, distribution channels, and what the small guys have is their innovative technology. And so that's why it's so important for to be able to enforce intellectual property rights the way Masimo is.
To that end, do you anticipate that, I mean, if you were to put probabilities on it, some sort of deal will ultimately be reached here? Masimo's been spending millions, yes, to ultimately potentially prove a point here and to fight for the smaller companies, but also because it thinks it could win a lucrative deal ultimately.
No, I mean, I don't know what Masimo's business objectives are. They have said they're willing to do a license. The question is always at what price, and is it a price that they're willing to take and Apple's willing to pay? And it also probably turns a lot on what happens on the 25th or the 26th when the president has to issue his decision. ITC vetoes are extremely rare. In fact, I think there's only been one in history. Now, Apple was the beneficiary of that one veto, so it may be feeling a little bit of invincibility here because it has such a well-known brand and such political clout. But we'll have to see what happens, and if the president doesn't veto it, that may bring Apple to the table.